So you might be surprised to find out that an attorney is here to try to dissuade you from running to the courthouse with your lawsuit. Because the truth of the matter is, litigation costs you way more than just money. I'm going to walk you through the strategies that I would suggest to any client who comes in the door seeking to recover from a bad tenant, a bad situation, or who's being sued, and the kinds of things that maybe you can do in the future to prevent ever having to wind up in front of a judge in the first place. So whether you're getting sued or you're thinking about a lawsuit, I want to make it plain and simple for you. All litigation is slow, it's expensive, and it is stressful. So it doesn't matter whether you are the plaintiff or the defendant in a case, the roller coaster is there and it's a rough ride. And so the smartest landlords do what they can to avoid litigation whenever possible. And that's going to mean finding out things in their infancy and putting out small fires that turn into nothing as opposed to a whole lot of trouble. So while there is a pretty broad range of topics where litigation can stem from between a landlord and a tenant, we're going to focus specifically on 3 topics: repairs, security deposits, and evictions. So repair issues kind of pop up all of a sudden, and sometimes without any kind of warning to you. Those tend to be the worst kind, something that's progressed over time that you have absolutely no clue about. But they pop up, and if dealt with diligently, if dealt with quickly, can be, stomped out pretty quickly. Sometimes small issues or really things that have absolutely nothing to do with the landlord pop up and cause big problems, particularly in the minds of your tenants. They might, for example, all of a sudden detect some spots in a vent, and they are shocked that their house is now full of mold. And so they see a small evidence of something and jump to a really big conclusion. And sometimes that results in a lawsuit. Maybe it's a matter of your tenant suddenly feeling unsafe. Something happened in the neighborhood, and now they are certain that their health or their safety totally at risk because of it. And again, it doesn't have anything to do with you, or sometimes it doesn't even have to do with the condition of the property itself, but there's something there that gives them pause, and they suddenly no longer feel safe and feel like this gives them an opportunity to skip out on the lease. Sometimes it's an issue that has to do with pests. Pests have overrun the property, and they're pointing the finger at you and saying, you have to deal with this. The question comes down to, what's the right response in each of these situations? Well, if you followed me enough, you know that I'm always going to say the very first thing is check out that lease. What does your lease have to say about each of these issues? I bet it says something about your right to diligently remedy any problem that might affect the health or safety of an ordinary tenant, and may even absolutely require you to remedy a problem that does have a material effect on anyone's health or safety. So when it comes to mold, I wouldn't suggest simply taking your tenant's word for it. I would investigate the matter, because sometimes things like dust or mildew are mistaken for mold. Something that can be remedied pretty easily with a little soap and water isn't going to merit total cancellation of the lease, and it's certainly not going to merit some extensive hospital stay. But sometimes, again, tenants blow things out of proportion and they make demands that simply don't line up with the facts. If it turns out that someone is feeling unsafe, what does your lease say about the safety involved there? Well, it probably says something to the following effect: we are not responsible for your safety at any time. The truth is, most tenants take their tenancy subject to their own duty of care. And so as long as the landlord isn't somehow creating the safety concern, The fact that a safety concern exists doesn't necessarily mean that the landlord has some duty to remedy it. Does that mean you have to put a guard outside the front door, or a security gate, or additional security measures that were not present at the beginning of the lease? Chances are very low that you're going to have to do any of those things, probably because they're not featured in the original lease and you have no obligation to utilize those. Now, there are certain specifics that are required under the law. You should be sure whether in your jurisdiction certain safety issues are taking effect on your property. Things like deadbolts, keyless deadbolts are important. Even those viewers in certain doors are required so that a tenant can be safe in certain apartment complexes. There are certain locking devices that are necessary for, say, sliding doors that aren't required in all units. But it's important for you to know what minimum safety precautions are necessary. Fire alarms, fire extinguishers. Check the rules of your jurisdiction to make sure that you have done what's required of you in the law, and then know exactly where the law no longer extends in terms of your requirement to produce a safe environment for your tenant. And when it comes to pests, generally speaking, a good lease is going to shift that burden onto the tenant. If you deliver a pest-free home and they do something that invites some kind of pest problem or exacerbates some problem, then they are likely to be found at fault and likely to be the ones required to remedy that situation. Understand the condition that you're delivering the property over to your tenants, and understand what your lease has to say about it before you simply react to an inflamed request making certain demands or sending you a bill for pest control when pest control is 100% on the part of the tenant. Other issues that can be a big problem when it comes to landlord-tenant law have to do with weather events. Sometimes a big storm comes through and what once was a perfectly habitable home is rendered somewhat inhabitable or completely uninhabitable. And so if that's the case, you need to know what your jurisdiction says about how to respond to this, and you need to know what your lease says. Now, in the event that a unit is only partially uninhabitable, let's say one bedroom was severely affected by some casualty event, like a flood or a fire, maybe a storm, a tree fell through, broke a window, a bunch of water came in, and now a certain bedroom can't be used, but the rest of the home is perfectly habitable. Well, in these situations, the Texas Property Code says that the landlord and the tenant can work out a diminished value of the property while the landlord gets that place repaired. It does not say that because the habitability was not 100%, that the tenant who's staying in place gets to stay in a new unit or in a hotel on the landlord's dime while those repairs are being taken care of so that the tenant can return to that unit. There's nothing in the law that says that, and most leases don't extend that to a tenant. Now, a tenant may have insurance to cover a situation like this, and we strongly recommend that landlords require this kind of insurance, but if they don't have it, they don't get this benefit, and they certainly can't require it out of a landlord who didn't promise it in their lease. So in the event that there is a partial issue of uninhabitability, you kind of work around that issue. You can reduce the value of the rent for the time being, but if the rest of the place is still usable, then it is the duty of the tenant to continue to pay rent and the duty of the landlord to complete that repair with diligence within a reasonable amount of time. Now, if a landlord is taking way too long to complete a repair and they have no valid basis for that delay, then a court could step in and award money damages to a tenant. In a case of breach, the landlord is sitting on their hands. They are required to get a certain repair done. They have not gotten it done, and it is now leading to unnecessary harm to the tenant. So the way we avoid this, landlords, is by always being diligent. Now, sometimes the issue of time is a factor dictated by things outside of the landlord's control, particularly after a natural disaster. Sometimes supplies are limited, labor is limited, and insurance also plays a factor in here. And so if a landlord is making an insurance claim and there's limited supply and there's limited labor, all these factors come into play, and kind of paint a picture of reasonableness if the matter is ever presented to a court, and the courts are likely to allow a landlord who, again, is still acting diligently despite these delays to assist the tenant and to complete this repair. So as long as you are doing what you're supposed to, if outside forces are preventing you and creating a legal reason for your delay, then you should be okay. In a good lease in the state of Texas, we have a rule that has to do with certain casualty losses. If there's a fire or a flood, something that was not caused by the tenant that compromises a condition of the property, and let's say it totally knocks it out, it makes the entire home uninhabitable, even for a short period of time, at that point, either the landlord or the tenant can simply call it quits. If a storm has come through and rendered a rental property 100% uninhabitable, either side has the right to simply issue written notice to the other side saying, we're not going to wait out the repairs. We're no longer going to stay here. We can't. I'm bringing this to an end. Now, the last set of repair issues that could lead to litigation all have to do with negligence. One of them is where a tenant noticed up on the ceiling, yep, that's a leak, and it's been there for a long time. I didn't get around to telling my landlord about it, and now what might have cost a couple of $100 to fix is now going to cost a couple thousand. That's a big deal. And so naturally a tenant would not have been on the hook for any damage if that tenant had reported it the moment it was discoverable. But the fact that they waited so long could mean that that tenant is liable for the additional costs that would not otherwise have been incurred had they followed their lease, which requires that they immediately report damages to the landlord. How you avoid having to file a lawsuit is by holding your tenants to these requirements. Now, the other easy way is for you to make routine inspections. And whenever you inspect, if your tenant has overlooked something like a leak from the ceiling, you should be there to catch it early as opposed to late. So every opportunity you get to go to the property, whether it's a routine inspection or a repair request for some other matter, you should be checking around the ceiling, the floors, the walls, the appliances. Make sure that everything is in good working order inside the house and outside the house. All the common places where things go wrong, make sure you're taking a peek before you leave. For the do-it-yourself landlord, we sometimes cause damage to our rental property. And by fixing things that we really don't have the expertise to fix, but we've done it a couple times pretty successfully, we might actually create, through our own negligence, the cause for damages that are incurred on our tenants. Remember, if something just busts or something breaks or a storm comes in, nobody's on the hook for that. And it's unfortunate that a tenant may lose personal property. That's what good insurance is for. And tenants are responsible for getting their own insurance to cover these kinds of damages. But, you know, if something breaks through no fault of either the landlord or the tenant, no one really is to blame. But if it turns out that the landlord, in some attempt to save money, actually creates a problem through their own negligence, perhaps they went left on the turn instead of going right, it caused a pipe to burst, and that burst pipe caused thousands of damage to your tenants. You know, that could be a cause of action that you're gonna have to deal with. And you gotta fess up. If you were to blame, you're probably on the hook for those costs. In other cases, we're dealing with a tenant who leaves and really wreck the place. They didn't take care of anything. It wasn't that the home itself was falling apart. They just didn't treat it well. They left holes in the wall, scuffs on the floor. They broke windows and twisted up blinds and just did all sorts of things, stains on the carpet and what have you. And they just left a whole lot of damage. These could be situations where you're thinking, I'm piping hot mad and I want to sue. Well, certainly you want to consider whether or not you have enough in your security deposit to cover these damages, but your security deposit might be gone relatively quickly based on the amount of these damages, and the security deposit won't be enough. The question for you is, does it make sense to go after these tenants? What makes the most sense, again, I keep going to these routine inspections because they end up really saving you a ton. If you've got a tenant who's been there for 3 years and you haven't been inside that house even once, you can expect some extensive damage. Now, hopefully for you, you show up and the house is in great condition, but you roll the dice every single time. Don't go more than 6 months without peeking inside the house, taking a look at what's going on there. Our recommendation is at the 3 and at the 9-month period, you are on the property checking things out within any 12-month term. After 3 months and 9 months, you're checking it out to see how they've started off and how they're going to finish off that lease. By inspecting this way, you guarantee that nothing goes too long without you having had access to the property and an opportunity to make things right. Now, if you find yourself in litigation having to deal with repairs, there are essentially 3 main issues that pop up every time. The first one has to do with notice. Did the tenant actually deliver proper notice to the landlord, giving that landlord an opportunity to make the repair? If so, you go on to the second issue that comes up all the time. Did the landlord in fact act with diligence? And you may have a situation where the tenant failed to give proper notice and the landlord also failed to act diligently, at which point the court's going to weigh the harms that were experienced in this case. And so maybe the lease required notice only through a very specified PO box, but they sent notice to the landlord through email, and the landlord did absolutely nothing. A court may still find in favor of the tenant, even though there's a technical problem with the notice that was delivered. A court may say, look, you had actual knowledge. You responded to that email and you should have done something about it, but you didn't. And because you lacked diligence, I'm going to rule in favor of the tenants. And then the final issue is, what was the status of the rent? Because in many leases, the landlord's allowed to just kind of wait it out and say, well, you haven't paid rent, you're not current on your rent, and so I'm not going to conduct this repair. But again, you sometimes have a balancing of equities, and courts will often look at whether or not the tenant is in compliance with the lease, particularly when it has to do with rent. But that may not be the absolute defense you think it is. In fact, a judge may say, I don't care if they didn't pay the rent. Their health or their safety was in jeopardy, and they experienced actual harm based on the defect on the property. And because of that, I will award them damages, even though they were not current on their rent. And I may deduct some of those rent damages from this, but you will pay their attorney's fees and their court costs and interest to them based on my findings. So yeah, your lease may give you an out when it comes to certain repairs, but I always tell landlords, don't just rely on that. You're gonna wanna act with diligence at all time. Whether the rent is paid or not, you're always in a better position being able to demonstrate to the court, I did all of my obligations. Everything that was set up for me to do, I did it. If anyone's in breach, it's the tenant, and so you should rule in my favor because of that. Now, when it comes to security deposits, sometimes landlords are taken completely by surprise because they don't understand the rules. In Texas, a landlord is required absolutely to return every security deposit they receive. And so it's important for an individual to know, well, what is a security deposit and what isn't a security deposit? Well, if you take a pet deposit, guess what? That's a deposit, and it is completely refundable. The fact that you make any deposit, whether it's the initial security deposit or the pet deposit, non-refundable, doesn't change what the law has to say about that deposit. And so don't rely on clever lease drafting to get you out of trouble when it comes to your security deposits. If someone has paid a deposit, it is refundable. However, if somebody pays a fee, that's different. There might be a parking fee or a late fee, or there might be a pet fee, a one-time fee that is paid off and covers whatever. And it's explained in the lease as a fee and not a deposit. That is probably not refundable. Now, definitely there are certain caveats in the law where improper fees are refundable, but we're going to assume that if it's in the lease, it's proper. But if it's a fee, probably not refundable. And certainly if it's regarded as a rent, not refundable. And so I don't tend to like when people charge pet rent, for example. I say just call it all rent. If you're going to boost the rent a a little bit because someone's going to have a pet on the property, don't refer to base rent and then pet rent. Just make the base rent the number that you agree upon because of their pets. Now let's talk about where people get in trouble when it comes to security deposit issues. One main thing that leads to a potential security deposit lawsuit has to do with the collection of bad evidence. And whether that's on the landlord side or the tenant side, bad evidence tends to lead to bad claims. And so what you don't want as a landlord is to be the one with the bad evidence. If the tenant shows up with a mountain of evidence showing the condition of the property and saying, look, all of these problems that you cited as being caused by me were actually there before the lease started. Now, you might say, well, they weren't mentioned in the inventory and condition form that I had you fill out within the first 3 days. And they may say, maybe not, but I didn't discover it until later. And now you're talking about a fact issue that a court could determine in favor of the tenants. And so don't leave it in the hands of the tenants to establish the condition before the property is leased. Make sure you can prove the absolute condition of the property before the tenants ever take possession. And you do that by snapping pictures and keeping receipts of the kinds of work you did on the property before the tenant ever took possession. Additionally, you know beyond a shadow of a doubt how old carpet is, when the painting was done, when the roof was installed, and things of this nature. And you collect all of this data for each of your rent houses in one location. Keep all your receipts, keep all of your invoices and all of your notes about the maintenance and care of your property together, because it might be necessary to demonstrate these things to a judge in the future. Now, if you paid for everything in cash and not one of your cash contractors offered you a receipt, or you simply didn't require it of them, you might be in a ton of trouble, because nothing is harder to prove than that work that you paid for from which there is no evidence. There's not a single photograph, there isn't an invoice, there isn't a phone number that somebody can call and confirm, hey, did you come and do this work in June of last year the way this guy's claiming? Don't put yourself in a compromised position. Even if you are paying cash, make sure you are always requesting some kind of receipt. And it doesn't matter that it's a basic receipt, but certainly the better evidence tends to be the most influential. So if you got crappy evidence, you might have a crappy case. So if you're paying in cash, consider the long-term costs of that cash savings. The next big issue that gets litigated in security deposit cases is that famous itemized list of deductions. If you are unaware of what an itemized list of deductions happens to be, you're en route to getting sued for a security deposit claim, because in Texas, every landlord is required to give an itemized list of security deposit deductions by default. Now, there are certain cases where that requirement is waived. But if you don't know those cases, you're gonna wanna prepare an itemized list of deductions every single time. The problem is not all landlords send them, or they don't send them within the required time period. Generally speaking, you've got 30 days from the day the tenant surrenders possession to send out that itemized list of valid deductions. Now, sometimes you're going to find that the tenant simply hasn't given a proper forwarding address, which is a requirement under state law here in Texas. So if your tenant has failed to supply you with a forwarding address, the clock for the 30-day limit really hasn't started ticking. I tend to recommend to landlords, there's a workaround for this that puts you on the right side of the law. Remember, you always want to be able to demonstrate to a court you did over and above even what the law required of you. So what I suggest is the tenant has moved out, it's within 30 days, they haven't given you a forwarding address, but you know precisely what you're going to deduct from that security deposit. And in bad situations, you are deducting the full amount and you've got damages beyond the security deposit. In other situations, you've got a balance, maybe even the entire balance, to send back to that tenant, but they still haven't sent you that forwarding address, and there's no way to get a hold of them. I mean, certainly if you have a phone number, or if you have text or email, you can reach out to them, but let's presume you've got absolutely no mechanism for reaching out to them to return a validly owed security deposit balance. Well, your last option is simply to mail it back to the rent house. Hopefully, they have forwarded their mail to their new residence, and so by sending it to that last known address, it eventually gets there, and then you can check your own bank statement to see that any check you sent is cashed, and you are now done with this particular tenancy. Now, if in fact it gets delivered to the property and is never forwarded, at the very least you have evidence sealed in an envelope, stamped by the USPS, showing that you attempted to send this notice within the time required by the law, even though the tenant had not offered you a proper forwarding address. Now, sometimes you have a landlord who has submitted an itemized list and sent it off to the tenant, and the problem comes when they send deductions to the penny for the exact amount of the security deposit. Simply to say, by the way, you get no refund because I had enough deductions to wipe out the entire security deposit. I tend to tell landlords that's a terrible idea for the following reason. You might have included something that you shouldn't have included. And if you owe even $1 or withheld $1 that you shouldn't have withheld, you can be sued, and you could be expected not just to pay back that $1, but to pay back sums in excess of that, including reasonable and necessary attorney fees. So don't put yourself in this position where you have exactly the amount of the security deposit. Now, if it turns out that's all you've got, then that's all you got. The problem comes up with landlords who could have mentioned, but I just chose not to. And I've never understood this thinking. If you can deduct it, if you can include it on your itemized list of deductions, including non-payment of rent, non-payment of late fees, non-payment of repair costs, maybe HOA fines, anything that you could include, you ought to include, so that if later a judge says, nope, 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 to these things, but there's enough left to justify a 100% deduction of that security deposit total, you'll be fine. What you don't want is to have a to-the-penny deduction of the security deposit with a few things left in your back pocket that you now cannot claim because you didn't give proper notice in accordance with the law. I would state everything that is a proper deduction that first time, and especially if it exceeds the security deposit amount, just to cover your bases in the event that some court disagrees with you and says that this deduction that you included was not proper. You want to make sure you've got enough to cover your bases. So let's talk about the kinds of deductions that get landlords in trouble. The first is that you've only included estimates. You don't have actual amounts of actual costs that you incurred. In fact, the worst of these situations is you only list out estimates and then you never actually get the repairs done. In fact, you lease the property to somebody else in the same condition that the previous tenant left the home in. Probably a terrible idea. It opens up the window for the court to determine clearly you really weren't actually damaged, and because of that, I'm going to erase these deductions from your list. Another problem is where the landlord asks for an upgrade. Right? So maybe one or two cabinet doors in the kitchen were messed up. Maybe a family pet just gnawed on the door and messed up a couple of the doors. And you decide, well, I'm just going to replace all of them. You're definitely allowed to replace them all. The question is, what is your damage calculation? If the dog damaged 2 doors, I believe you're rightfully entitled to replace 2 doors. So whatever is just is what you can charge. You can't charge for the entire thing. And you may say, well, it's not going to match unless I do the whole thing. At which point, you're gonna have to have a judge agree that that's a big enough issue to justify the full cost. Otherwise, you're probably gonna be stuck just replacing those 2 doors. The upgrade that you now get is something that you get to carry forward. Maybe it increases the property value, or maybe it just increases the aesthetic value of the kitchen. In any case, you may not be able to charge that full value to your tenant. And the final thing that causes landlords so much trouble in security deposit cases is when they attempt to charge their tenants for damage to the property that is within normal use and is ordinary wear and tear. Let me give you a few examples that are very, very common. Let's say you lease a property to someone and the carpet in the home at the time is about 5 or 6 years old, and those people stay there for 2 to 3 years. Well, once carpet reaches about 8 years old, there's little to no value left in it. Now, you may say, hey, look, if they had done a better job of taking care of it, the carpet would have been fine. I would have been able to lease it to somebody else and it would have been just fine. But that's not exactly the calculation that a court's going to go through. The question for the court is going to be, at year 8, what's the value of 8-year-old used carpet? Could you find a market where someone would be willing to buy 8-year-old used carpet? And if so, what would they pay for it? They certainly wouldn't pay the same price for brand new carpet. And so when you're calculating your damages, you have to know the value of the thing that was damaged and whether the majority, if not all of it, of the damage that was caused was through normal use and ordinary wear and tear. Another thing that's quite ordinary are tiny holes in the walls where pictures were hung. And so if you find yourself counting little holes in the wall, I don't know that a court's going to agree that that isn't ordinary. Now, giant gaping holes, maybe from fists that went through a wall or doorknobs that got slammed, or maybe some wall-mounted television set that kind of tore off sheetrock when it was removed. Those sorts of things are not ordinary, and so you can charge for that. But tiny holes in the wall for pictures, you're probably not going to get any court to agree that that exceeds normal use or ordinary wear and tear. So be judicious when you are tabulating the fees that are owed, and don't charge for things that can be deemed ordinary and normal wear and tear. So security deposit cases in Texas, are interesting because generally speaking, a plaintiff who brings a case has the burden to prove the facts and the elements of the case. But in a security deposit dispute, a plaintiff can be the tenants who are suing the landlord, and the landlord now has that burden shifted to them, not to prove the damage, but to prove that it was a rightful deduction of every single dollar that was removed from that security deposit. That shift in the burden gets really difficult if you don't have a good record. So a big part of security deposit litigation has to do with what a landlord can actually prove. Do you have photographs before the tenancy took place and after the tenancy was over? If you do, you could be able to show a court just how much damage a particular tenant caused. Do you have receipts and invoices and an ability to prove the kinds of things you did right before the tenancy and then the condition of the property after the tenancy to justify things like the cost to repaint, the cost for carpet, or the costs of other repairs that were necessary due to the damage caused by the tenant? And finally, the issue of unpaid rent comes up in these cases. In the state of Texas, if a tenant leaves owing rent, again, that's that situation where a landlord might not be obligated to send the itemized list of security deposit deductions. But even if that's the case, I still strongly recommend that landlords do it. You want to do it just to cover all of your bases and not leave any option for a tenant to come after you with a lawsuit and a viable claim. And you end up being, again, in the eyes of the court, the most compliant with the law and with the terms of your lease, and likelier to win your case. Now, the most common litigation that we see has to do with eviction cases. And these are the ones that frustrate landlords the absolute most, particularly when it comes to non-payment of rent. But not all eviction matters stem from non-payment. In fact, sometimes a landlord will, on their own, present a case to the court simply because they're sick and tired of their tenant, but they don't have an actual cause of action. They maybe don't like their attitude, or they yell at them all the time, or they're constantly asking for repairs, but none of these are necessarily a violation of their lease, and they're not a per se violation of state law. So those evictions go nowhere. Sometimes a landlord is interested in filing an eviction because the money doesn't make sense anymore. It's too much trouble, it's too much hassle. I've done this for so long and I just want to call it quits. And so they figure, it's my house, I can do what I want, I'm going to send a notice to vacate. I'll even give them 30 days. But if you're still within a lease term, you don't give them anything. You have to honor the full length of that lease. And if there's still 6 months left, the fact that you want to call things quit doesn't mean you get to. Another reason that landlords ultimately say, I want out of the landlord game, is because they feel there's no such thing as good tenants anymore. I tend to disagree with that pretty strongly. I know there's plenty of good tenants out there, but sometimes, the way that we approach tenants or the things that we do or the mechanisms that we've used aren't very good. And so this misconception that good tenants don't exist kind of lead landlords to an antagonistic position, and they rush to the courthouse thinking that eviction is the solution to bad tenants, when maybe there are other reasons. One of those reasons might be late or non-payment. And so I want to talk about late payment first, because this sometimes gets landlords into trouble. Because they'll say something to me like the following. Look, I've had this tenant for 2.5 years, and every single month it's been the exact same thing. They pay late, they've got excuses, I gotta hound them every single month. And so I ask, of all the times they've paid late, would you say it's more than 10? Heck yeah, it's more than 20 times. Over 2.5 years, more than 20 times they've paid late. Great, I say. And how many notices of default have you sent? Crickets. Because they haven't sent a single one, their tenant is likely to argue, hey, I've done this from the beginning, and he always accepts the rent. And a court might agree that your course of performance means if you've tolerated it for 2.5 years, why am I suddenly going to care? You're getting the rent paid, you're accepting the rent, and you've never once issued a notice of default. If you want to hold your tenant to the terms in your lease, but you're not issuing notices of default, then you're essentially waiving those terms, and you can't all of a sudden have the court bail you out because you suddenly want to enforce your lease. Now, I'm not saying it's a bad idea to enforce your lease, but I am saying that if you rely on this without notice, the court's not interested in hearing what's been going on for the last 2.5 years, because in their ears it kind of sounds like waiver. Now, excuses roll in all the time. Maybe there's a medical cost, maybe there's slow work, or some other issue, a car repair, grandma dies, things happen, but that's real life. And there's nothing in your lease, probably, that gives them that out, that if life goes sideways on you, you don't have to pay rent, or you can delay 10 or 15 days in paying the rent. That simply doesn't exist in the law, and almost certainly doesn't exist in your lease. That doesn't mean those excuses won't come. Sometimes it's an issue of roommates, and one roommate, who is the angel of the pair, always pays their rent on time, and the other roommate, the little devil, never pays their rent on time, and you only want to evict the one. Well, in the state of Texas, you simply cannot do this. If you're going to evict anybody, you have to evict everybody who signed the same lease. Remember, there's probably a term in your lease that has to do with joint and several liability, which means that everybody together is fully responsible for the entire rent. And so this goes to both non-rent violations, but definitely to the rent. It's not split up in any proportionate way. 100% of the rent is owed, and it doesn't matter who pays it. Now, they may divide it in a certain way between themselves, but that doesn't matter to the landlord. And if the lease says X is the total amount owed, and if X is not paid, then everybody on that lease is subject to eviction. So there are a number of non-rent lease violations that can lead to an eviction. One of them has to do with the tenant changing the locks or somehow preventing the landlord from entering the property. This is unfortunately something that happens pretty often that, some landlords just kind of disregard. They figure, well, they don't feel safe, so they're allowed to change the locks. But have you read your lease? Your lease is probably black and white explicit and says you're not allowed to do that. And if that's what your lease says, you should be issuing notices of default. If your lease allows you a reasonable access to the property for an inspection or for repairs, and your tenant simply denies you and makes up excuses why you simply can't, including raising privacy concerns. I mean, if it's already in the lease and your jurisdiction allows you to enter, there's no reason for the tenant to prohibit you from stepping onto the property. Other times, a tenant will cause damage to the property because they were trying to fix things. When you allow your tenant to make repairs, they'll sometimes do it to the best of their talents and abilities, and that's not always very good. However, if your lease strictly prohibits the tenant from altering the property, and you certainly didn't give any permission, but maybe they decided to paint a room and figured, oh, no, I'll take care of it. I'm good at this. I do this professionally. I mean, if they didn't get your permission and it's prohibited in the lease, the fact even that they did a good job doesn't mean they didn't violate the lease. So definitely if they've harmed your property, you want to get ahead of that, get notices sent. But even if they haven't harmed your property, you want to remind them in the future, this could be something you get evicted for. Don't do this without asking my permission. I'm looking at it, looks good. I'm going to waive the problem now, but I'm not going to waive the issue of the lease violation in the future. Make sure you ask. That's all. And I may give you the thumbs up, but I'll likely give you a thumbs down because it's probably best for the tenant not to do these kinds of things on the property, especially without permission. Finally, if someone's got an unauthorized pet that's just terrorizing the place and causing damage, you're going to want to issue those notices, tell them to get rid of that pet. But if they can't control the pet or they won't get rid of it, your last option is simply to file for an eviction. And if you can do anything to prevent that, that's always advisable, but sometimes you can't prevent it. In many of these instances, if they simply stop paying rent or they won't stop harming the property in some way, your only option is an eviction. But if you can prevent it by, being on the property and, issuing notices, again, that's probably going to put you in the better position not to have to waste time, money, and energy in the eviction court, but also by not burning a bridge with your tenant. It could be that a simple notice helps them to get things back where they should be, but if it doesn't, then of course that's what the eviction courts are there for. So when it comes to winning an eviction case, there's really just a few basic topics that the courts are even interested in hearing. The first being whether you as a landlord can prove that the tenant substantially violated the lease. We sometimes say when it comes to rent, if you're $1 short or 1 day late, you, the tenant, are subject to an eviction. And while that's technically true, if you're literally suing for $1, I don't know that the court's going to find that that is a substantial breach of the lease. So be wary of that. But if you're talking about an entire month or half a month, then yes, now you're getting into more serious territory where a tenant is likely to be evicted. Next, did the landlord actually deliver proper notice? Now, this is going to vary from jurisdiction to jurisdiction. I'm not going to get into the kinds of rules that might be violated here, but make sure you understand the rules of your jurisdiction. In Texas, there's all sorts of valid ways to give that notice to your tenant. If you don't know what those valid ways are, you should contact an attorney and make sure you're doing it right every single time. And finally, you want to show up with all of the right evidence. You want to make sure if you are the landlord showing up to the eviction court, you've got everything to prove your case. Hopefully, if it's a non-rent issue, you're showing up with multiple notices, with photographs, with invoices, maybe even eyewitness testimony from other parties who can assist you in building your case. Definitely, if it's a rent matter, you're showing up with your ledger, you're showing up with your notices, maybe even your communication back and forth with that tenant. But basically, you want to make sure you are ready to prove all the elements of your case so that you can be successful. Now, the most successful landlords out there are all about prevention. If you're aiming for the courthouse, you've kind of overshot. And so I'm going to give you some tips on how to utilize the best strategy for, preventing issues from ever having to result in some kind of lawsuit, either where you are being sued or where you are forced to sue another individual. The first tool is a well-crafted, very clear lease. You want to be able to demonstrate to your tenant exactly what your expectations are by utilizing a good lease with very clear terms. It shouldn't be a mystery how much the rent is and how it gets paid, what happens if it's paid late, how repair requests are made, or how deposits are handled. If your lease is crystal clear, you're less likely to have controversy between you and your tenant. It tends to be that when things are ambiguous or just not explained very well, that trouble results. I encourage landlords to have a sit down with their tenants right before the lease begins and kind of explain the key points, and by letting them in on your routines, like how you conduct repairs, how you do inspections, who the emergency contact is, what are some of the common things that will likely pop up in your lease, particular to your property or particular to your management style. By sitting them down and running through these things with your tenant, you're more likely to get them to comply with the terms in that lease. You're also going to want to develop a habit of quick responses. Now, you might not just show up at the doorstep at their first call, but it is a good practice to have quick responses, whether that's through email or through text, with your tenants. Now, I recommend that everything you do when you communicate with your tenants should be in some kind of written form. And so right now, I tend to favor email communication because you can prove the time that it was sent. And usually when you communicate through email, it's pretty clear. Text can be very conversational, and sometimes it's hard to prove a whole series of text to a court. But an email is easy because each email kind of comes off like its own letter, and it's very easy to produce these records for the court. And so I prefer email as quick communication that you can demonstrate to a court, potentially at future litigation. But make sure that you are conducting yourself in a professional way when you are communicating through email. You don't want to be overly friendly, but you also don't want to be overly rough with any of your tenants. Make sure that the statements that you are presenting in these emails are professional in nature and something that you wouldn't otherwise be embarrassed to end up in front of a judge in open court. Finally, make sure you have a strategy for fairly but firmly enforcing all of the elements in your lease. You want to make sure that if it's in there, it's there because it's important to you. And if it's important to you, you are making sure that the tenant understands that it's important to you and a requirement in this lease. You do that, number one, by talking about it ahead of time, and number two, by issuing notice when there is non-compliance. By staying on top of it, you might actually prevent any matter from ever snowballing into a huge litigation nightmare. Landlords, I hope you have enjoyed today's video. We have a ton of videos on varying topics, all about landlord-tenant law. I welcome you to check those out. Right now, YouTube seems to think that this set of videos right here is the next best thing for you to watch. I strongly encourage you to check that out. And until next time, landlords, happy leasing.